Your Lordship, may I make a mention on item number 12, hearing list. This
Yes.
I'm being led by Mr. P. Goswami. So he has asked me for adjournment. Let it come up on next week, 22nd.
Who's for the other side?
I'm here, Lord.
Any objection?
No objection, Lord.
Okay, as paid for on behalf of Mr. P. Goswami, Learned Counsel,
Respondent 1 to
the
3.
respondent number
1 to 3.
1, 2, and 3
Yes.
by Mr. Roshan Subedi and not objected to by the other side. List the matter for hearing on 22nd of October 2024.
I'm obliged.
Yes.
Obliged.
May I seek your Lordship indulgence in mentioning item number 9?
Yes.
Lordship, my senior is unable to attend the court due to some personal matters.
To Mr. Joseph,
Yes,
Mr. Malhotra.
yes, Lordship.
I believe he's getting married next week.
Yes, yeah,
When?
on the 24th, next Thursday.
You want the matter to be heard on the marriage date?
No. When? Sorry, your Lordship.
When?
After 3 weeks.
3 weeks. Mr. Malhotra.
It's okay.
Mr. Joseph Elrentley, Learned Counsel for the respondent, is said to have some personal difficulties to conduct the case. And therefore, on a prayer made on his behalf by Miss
F. Lazarzovi.
F. Lalzarzavi, Learned Counsel, and not objected to by Mr. A.R. Malhotra, Learned Counsel for the petitioner. Matter stands adjourned for 3 weeks. Yes.
Yeah, please, Your Lordship, I would like to make mention of item number 10, Lordship. We'll be filing the Vakalatnama in the course of the day, Lordship. So if this matter may be taken up after 1 week,
You are for the,
I'm for the petitioner, Lordship.
what's your good name?
Appellant.
Appellant,
Your good name?
David Lalompuya.
Mr. David Lalompuya, Learned Counsel, submits that he has instructions to appear on behalf of the appellant, and he prays for a week's time to file his power and prepare the matter. Stop. Mr. A.R. Malhotra, Learned Counsel, appears for the respondents, and he has no objection. Next para, in view of above, list the matter again after a week.
After a week, Lordship.
Yes.
I'm obliged.
Obliged.
For admission, item number 1.
Your Lordship, I'm appearing on behalf of my senior, Mr. A.K. Ropum, and it's regarding the rental charges of the BSF, Border Security Force, unpaid rental charges. And we are still waiting for the update of the analogous case from the Apex Court.
Okay. So when do you want it?
Your Lordship, if the matter may be listed after 2 months.
2 months.
Yes.
It is submitted at the bar that the outcome of SLPC number 39161/2018 / civil appeal number 245/2024 is yet to be disposed of by the Apex Court. Full stop. The outcome of the case would squarely cover the present case, according to the Learned Counsels. Next para, in view of above, and as paid for, matter stands adjourned for 2 months.
Much obliged.
Item number 2.
Yes.
Yes, Your Lordship. Respondent number 5 to 7 has to file their affidavit.
Respondent number 5 to 7.
Yes, Your Lordship. 6 to 8. My apology.
Others have filed.
Yes, 1 to 5 has already filed.
Ms. Malswamy and Ms. Linda. Any one of you handling this matter? Last time Ms. Banesiami had appeared. She's not come today.
Lordship, Miss Mary is appearing on this matter. I believe she has some personal difficulty today. So, if affidavit is not being filed till date, so if another time may be given, Lordship, some more time.
On the request made on behalf of Ms. Mary L. Kyangte, learned government advocate, who is said to be appearing for the state respondents in the instant case, the matter stands adjourned for 2 weeks. Affidavit be filed in the meantime.
Oblige.
Item number 3.
May it please your Lordship, this is a regular first appeal against the judgment and order dated 18th of September 2018, passed by the trial court in civil suit 30 of 2008, Your Lordship. And after the delay was condoned, this is the first time the matter has been listed, Your Lordship.
What is the judgment?
If I may take Your Lordship to page Roman 7 of the judgment.
Yes.
Your Lordship, para 14 of the judgment, altogether 8 issues were framed by the trial court. And issue number 3, whether the plaintiff has any rights, title, interest over the sued land. And number 4, whether the plaintiff has any locus standi to file the suit. Number 7, whether the sued land is under occupation of the defendants, and if so, whether such occupation is legal or not. So the trial court had decided all these issues, 3, 4, and 7, in favor of the plaintiff. That the sued land belongs to the plaintiff and the defendants are in illegal possession. But with regards to issue number 2, the trial court had held that the suit is barred by limitation by relying on Article 65 of the Limitation Act.
12 years.
Yes. So the main grounds of appeal is that the trial court has misinterpreted Article 65 of the Limitation Act because the respondents have never pleaded adverse possession.
So, all right, we admit and will issue a call for the LCR. But Mr. Yar Malhotra, learned counsel for the appellant, who submits that, being aggrieved with the judgment, an order dated 18/9/2018, passed by the Court of Senior Civil Judge, Roman 4, Isol, in civil suit number 3030 of 2008. The appellant has filed the instant appeal. To stop, he submits that the instant appellant was the plaintiff before the learned trial court. And the learned trial court, although decided most of the issues in favor of the appellant, but dismissed the suit ultimately on grounds of delay. Stop, the learned counsel submits that the learned trial court has misinterpreted Article 65 of the Limitation Act in view of the fact that the opposite party had never pleaded adverse possession. Next para, in view of above, let the appeal be admitted. Call for the LCR. Issue notice to the respondents, returnable by 3 weeks. Ms. H. Lalmal Swami, learned government advocate, appears and accepts notice on behalf of the respondent numbers
3 and 4.
3 and 4, while Ms. Zairam Sangpui, learned CGC, appears and accepts notice on behalf of respondent numbers 1 and 2. Anybody else?
No, Your Lordship.
Stop, service is therefore complete. Appellant shall serve requisite extra copies of the memo of appeal to the learned counsels appearing today, if not already done. List the matter again after 3 weeks along with the LCR.
Item number 4.
My lord, for the respondent number 4, Then I may be given some more time for filing my affidavit in opposition. Then some other similar matter has been fixed on 25 October, my lord. The matter may be fixed on that day.
Yes, who else is appearing?
Yes, my lord, I'm appearing for respondent number 3.
Number
Respondent number 3.
3. When are you going to file your affidavit?
My lord, my senior who is the leading counsel is out of time, and I'm praying for more time to file for
Okay,
counsel.
and others? 5 and 6 are filed.
Yes, Your Lordship.
Who else?
My lord, 1 and 2, we are not filing affidavit.
Okay, Miss Linda L. Fumble, learned additional AG, appearing for respondent numbers 1 and 2, submits that respondent numbers 1 and 2 will not be filing counter affidavit. Stop. Mr. Samuel Valrishita Changte, learned counsel, appearing for respondent number 5 and 6, submits that respondent numbers 5 and 6 have already filed their counter affidavit. Stop. As for the remaining respondents who are represented by Ms. Zairam Sangpui and Mr.
LS Laram Chuana.
L.S. Nalram Chuana. Nalram Chuana. They pray
On
that
behalf of my senior,
for the, how much time?
2 weeks.
Further 2 weeks may be granted for filing counter affidavit. Prayers aloud. You said on 25th some other matters coming up.
my lord.
What is that? What is the case number?
Not, as on date, I do not remember that matters, my lord.
Okay, you find out, let us know. List again after 2 weeks.
Item number 5.
In the beginning part you had, Miss Valentina Nal Dinpui appears for the petitioner. Okay, yeah. That. Yes.
Your Lordship, service on the thesis is complete.
Okay. 8, 10, and 15
Yes,
by Dusty. And if nobody else is remaining?
no.
Okay, and what about the counter affidavit from the state?
1 to 6 we have already filed.
Okay.
Some of the my lord, some of the respondents have told me that they are going to file counter affidavit.
Have they engaged anybody? Have they engaged any
I
advocate?
don't know.
Not yet.
Not yet.
Okay, so we'll adjourn it for a week or 2 weeks? 2 weeks.
Yes, my lord.
Mr. R. Laltamruata, learned counsel for the petitioner, submits that the respondent numbers 8, 10, and 15 have been served notice by way of Dusty as permitted by this court, and that an affidavit to that effect has been filed. Stop. On perusal of the affidavit, notice upon respondent numbers 8, 10, and 15 are accepted. Stop. Ms. Linda L. Fumble, learned additional AG, appears for the state respondents and submits that the state respondents have already filed their counter affidavit. Stop. Since the private respondents are not represented today, the matter stands adjourned for 2 weeks. A counter affidavit may be filed by the private respondents in the meantime, if so advised. Yes.
Item number 6.
My lord, I have filed my affidavit on behalf of respondent number 1, 2, and 3. However, I have yet to file for respondent number 4, Assam Rifle. Then I'm seeking 2 weeks time for filing my affidavit in opposition.
And Mr.
Similar
Rosh,
prayer for the state respondent.
respondent numbers?
Respondent number
5 to 8.
5 to 8.
Okay.
In the meantime, my lord, I would like to file a rejoinder affidavit to the affidavit in opposition filed by the respondent 1, 2, and 3.
Okay. Please write, although the respondent numbers 1, 2, and 3 have filed their counter affidavit, the remaining respondents have not filed the same. Stop. Ms. Zairam Sangpui, learned CGC, appearing for respondent number 4 and Ms. Linda L. Fumble, Learned Additional AG, appearing for respondent number 5 to 8. Pray for and are granted further 3 weeks' time to file their counter affidavit. Stop. The petitioner is also given liberty to file a rejoinder affidavit against the affidavit in opposition filed by the respondents within the said time. List the matter again after 3 weeks.
Item number 7.
My lord, I have an instruction from my client to pray for time to file additional document, my lord.
Additional document.
To the petitioner in their reply affidavit, my lord, stated that the vice chancellor is not competent to constitute a review committee, and we want to show from the acts and statutes of the university that he is competent. So for that purpose, my lord, we need 3 days or 2 days. By this Friday, my lord, we can file additional affidavit.
All right, you file,
My lord.
Mr. Malhotra.
It's okay.
We have it next week then.
Next
Yeah,
week.
my lord, we can do that.
Mr. L.H. Liantrima, Learned Senior Counsel, appearing for the respondents, submits that taking into account the averments made by the petitioner in the rejoinder affidavit, the respondents would like to file an additional affidavit in opposition. Which would be, affidavit in opposition. Okay, that much will do. Stop. In view of above, the matter stands adjourned for a week. Respondents to file their additional counter affidavit in the meantime.
Obliged, my lord.
If a date may kindly be fixed,
When do you want it?
24th, 24th, Thursday,
24th.
Thursday.
My lord, that will
List the matter again on 24th of October 2024 as paid for.
oblige.
Item number 8.
Yes. My lord, pleading is completed. I have already submitted my affidavit in reply also.
Are you ready for hearing then?
Yes, my lord.
You're ready?
Lordship, it's a simple matter. I believe, although I'm not quite prepared, but however, Lordship, we can dispose of the matter.
Okay, so let him start.
Yes, my lord.
So what is the matter about?
In this matter, the petitioner was issued work order on dated 5/10/2023 by the respondent number 4, who is the executive engineer of the
Page 11.
UDNPA.
Page 11.
Yes, page 11.
Mahak, you may go.
3
I'll call
contract
you if you
works were issued.
want. Sorry?
3 contract works were issued to her.
Is it page 11?
Yes, page 11.
Okay.
Page 10, 11, and 12.
Okay, separate.
Those are the, yes, separate contract works.
What kind of work is this? Repair of drain, reconstruction of step,
Yes, with
Then-
handling railing. These are the small works.
drain bed
Yes,
with RCC. Okay,
about 8 lakhs, 4 lakhs, and 5 lakhs.
okay.
Yes. Then the same works were cancelled by order dated 16 to 2024. They are on page 13, 14, and 15.
Where was it cancelled?
The reason for cancellation was not reflected in the said order. It is arbitrarily cancelled without mentioning the reason for cancellation of the
Okay,
works.
the work orders are all dated 5th October,
Yes, all dated 5th October.
and time for completion of the work is 12 months.
Yes, 12 months.
That means by October 2024, you have to complete.
Yes.
Now, what are the formalities after the work order is issued to you, are you supposed to sign an agreement or something like that?
In these small works, it is usually work order was issued, then the work was started, then after completion of the works, bill was submitted, then the bill were issued to them.
There is no separate agreement and all that.
Yes, no such agreement was.
And on what basis this work order is issued to you?
This work order was issued by the government.
No, I'm asking you the basis. Like, is it an open tender like that, or it's
It is not open
a
tender.
restricted tender, or it's pick and choose?
It is a it is a pick and choose. Yeah,
Yes,
admitted.
you should be frank about it. It's pick and choose.
Yes, it is not a true tender or
Okay.
open tender or restricted tender.
Now they decided to cancel it.
Yes, decided cancel it.
So what is wrong in that?
It is wrong in that it is not the reason for cancellation was not made out by the government in cancelling the sale,
So
which was
see,
allotted to.
it's not that after floating the tenders, floating the NIT, there were many tenderers, prospective tenderers. After going through the entire selection, you were chosen and given the work order. Now abruptly they've cancelled you.
Yes,
That is one thing.
yes,
Another thing is, okay, they say that Mr. XYZ, you come. This is a work order for you. Go and work.
yes.
But after a few months, they say you cancel. So what right do you have that the work should be done by you, considering the mode of selection, considering that there was no selection?
I was selected to proceed with the works, and work order was duly awarded to me.
And that though we've seen.
Yes, while I am preparing to start the works and collecting the necessary materials, it is arbitrarily cancelled. Then, since there is
What
no
materials have you collected?
yes, I am preparing
What materials?
that
Like what?
the materials required for for doing these works.
Like what?
Yes,
Stones,
stone
bricks,
chips, yes, cement like that, iron rods, etc.
cement.
Yes.
Where is the cement now?
Since the work is cancelled, we have already disposed of them.
That's what.
Yes.
So basically, I think your case is that without giving any notice, you have been
Yes.
issued this cancellation order.
Yes.
That much only. But
Yes.
question is, what is your substantive right to do the work?
Yes, my lord. The respondents in their reply affidavit, affidavit in opposition stated that in their affidavit, page number 6, it is written that in pursuance of para 6 of the minutes of the meeting of Council of Ministers held in the recess room A of Mizoram Legislative Assembly, annexed on 13 December 2023, conveyed White number dated 14/12/2023. All departments under the government of Mizoram are requested to comply with the following points as enumerated under. The point number 1 is works for which work order have been issued and which have been already started on the ground prior to enforcement of the Model Code of Conduct will continue. The number 2 is, however, those works orders for which works were not started at the time of enforcement of Model Code of Conduct will be stayed. That is the reason for cancellation of my contract work. Then in page number 7, the Undersecretary to the Government of Mizoram had submitted, had informed the decision of the government. Here it is written that
So, this number 2, point number 2,
yes,
when was the model code of conduct enforced?
the work order was issued to be on 5th October. Then the model code of conduct was enforced on 9 October 2023. After 4 days, my contract was awarded to me.
9 October
Yes, 9
2023.
October. Then counting of vote was on 3rd December 2023. Then
Sorry?
3rd December 2023. My lord, I have here the press note of Chief Electoral Officer, Government of Mizoram, with regard to this.
Okay. So, the work order was issued to you on 5th October.
Yes, 5th October.
Now, Model Code of Conduct came to be enforced on 9th of
9
October.
October, my lord.
Then counting of the ballot papers
Where
was
on
done on 3rd of
3rd December.
December.
Yes. Then the swearing in of the new government was held on 8th December.
Okay, so it says, however, those works orders for which works were not started
Yes.
at the time of enforcement of moral conduct will be stayed. So you may not have started your work, isn't it?
Yes.
On 5th October, so
Yes.
5th October you will receive the work order.
Yes.
6th October you cannot start straight away.
Yes.
6, 7, 8, 9, just 4 days.
Yes. Actually, it is 3 days.
Now, when did you come before this court?
The first order was on
6th March.
yes
You
8th.
filed your writ petition on 6th
Yes.
March.
Yes.
Any interim order? Any interim order?
Yes.
No.
Interim order was there. 8/3. 8/3/2024. An interim order.
This
was
is
passed.
remaining.
The
Interim order continues, isn't it?
Yes, yes. And as far as our information, the works were not allotted to any other person till then.
Okay. What is your instruction, Miss?
I don't have any instruction except the statement which we have written in our affidavit that the work order was,
Work order was issued to him.
yes,
Just after 4 days, MCC came into force. Then the circular says that work which has not started,
should be
they should stay.
yes.
So work probably did not start in his case. So ultimately, work order was cancelled.
Yes.
But next year, on 16 February. Correct. You were asked to stop the work verbally, or what was
Yes.
done?
I am about to start the works after the election was over.
Uh-huh.
But the officials of the UDNPA department told me that you please wait for some time. You will continue to work, but you have to wait for some time. They have repeatedly told me that. But ultimately it was cancelled.
Okay.
That is.
See, we can do one thing. What has happened has already happened.
Yes, my lord.
Now, the UDNPA may want to complete the work.
Yes.
In such event, you should be considered
Yes.
to undertake the work, having regard to the fact that you had earlier been issued work order.
Yes, ma'am.
With that observation, perhaps we can close it. But there is no guarantee that he should be given or others should not be given and only he should be given. We can make an observation that since you have been given the work order earlier,
Yes. My lord, one judgment with regard to this I would like to submit.
yes, what does it say?
In- In the last page, my lord, para number 129.
Yes.
We caution the public authorities to be circumspect in disturbing or wrangling out of its contractual obligations through means beyond the terms of the contract in the exercise of their executive powers. We do not say for a moment that the state has no power to alter or cancel a contract that it has entered into However, if the state deems it necessary to alter or cancel the contract on the ground of public interest or change in policy, then such consideration must be bona fide and should be earnestly reflected in the decision-making process and also in the final decision itself. We say so because otherwise it would have a very chilling effect, as participating and winning a tender would tend to view it as a situation worse than losing one at the threshold.
This is there, Mr. Pianfella. See, we are also not oblivious.
Yes.
We are also aware of the fact that
Yes.
you have earned your work order
Yes, my lord.
during the earlier ministry.
Yes.
New ministry has come, they said, no, you wait.
Yes.
We have our own people to work for.
Yes.
This is the, to be very frank about it, this is what's happening.
Yes, my lord.
You should not have been given work order like that in the first place without
Yes.
floating tenders or without any competition.
Yes.
Because the people who have given you the work order, they know very well that election is around the corner.
Yes.
Very soon the model code of conduct is going to be enforced.
Yes.
So let us quickly give something to somebody.
Yes.
Perhaps that was the intention.
Yes, my lord.
So after considering all these aspects,
Yes, my lord.
if we balance what is right, what is wrong, perhaps they should go for allotment of fresh work orders in which event you should be given consideration, having regard to the fact that you had earlier been already given that work order. That much observation I can give you. Apart from that, see, if you had been selected through regular process,
Yes.
definitely we would have considered the impugn order and maybe interfered with it. But since there was no such kind of process, you also have rightly admitted that I have been asked to do the work. I'll do it. But why did you cancel it without giving me chance to,
Yes.
without notice? This is what you have said.
Yes, my lord. Moreover, the respondents are silent with regard to the validity of the work order in their affidavit in opposition. Also.
Okay. But the work order speaks for itself, isn't it? There's nothing. Director's approval was there.
Yes.
So we'll close the matter in that line.
Yes, my lord.
Please call somebody. Okay. I think, Ms. Malswamy, nothing much can be said about it.
Yes, yes, about you.
It's item number 8. Heard Mr. Lalpian Philatsongthu, learned counsel for the petitioner, and Ms. H. Lalmal Swami, learned government advocate, appearing for all the respondents. Stop having regard to the nature of the case projected by the petitioner, the writ petition is taken up for final disposal at the admission stage. Stop. It is the case of the petitioner that he was awarded three different works under the Directorate of Urban Development and Poverty Alleviation. bracket UDNPA wide work order as wide work orders all dated 3/10/2023. Stop. As per the work orders, the works described were to be completed within 12 months from the date of issue of the work order. Stop. The petitioner therefore started collecting necessary raw materials for undertaking the construction work but in the process, he was informed by the officials of the UDNPA not to begin the work but wait for some time. In view of the State Assembly elections. Stop. While the petitioner obediently waited for the instructions to go ahead with the work, the Respondent number 4 abruptly issued the impugn order dated 16/2/2024, by which order S will be required. Impugn orders after that all dated 16/2/2024, cancelling the work orders issued to the petitioner. Stop. Aggrieved. The petitioner is before this court. Next para. Mr. Lalpian Felachongthu, learned counsel for the petitioner, submits that prior to issuance of the impugn order dated 16/2/2024, no notice or opportunity was given to the petitioner to show cause as to why the work orders that were issued to him should not be cancelled. Stop. In fact, the petitioner had already collected good quantity of raw materials to undertake the construction work. Stop. With the issuance of the impugn cancellation order, the petitioner has suffered great loss and hardship. Stop. He therefore submits that the impugn cancellation orders should be set aside and the petitioner should be allowed to undertake the work in terms of the work orders issued to him. Stop. Stop. In support of his submission, he relies upon the case of Subodh Kumar Singh Rathore versus Chief Executive Officer and others, 2024 SCC online SC 1682. Staple this. Staple it. Next para. Ms. H. Lalmal Swamy, learned government advocate, on the other hand, submits that the although the petitioner was issued the work orders on 5/10/2023, but on account of the ensuing state assembly elections, the model code of conduct came to be enforced in the state with effect from 9/10/2023. And by that time, the petitioner had not started the work. Stop. The government of Mizoram in the General Administration Department had issued a circular on 18/12/2023 by which it was decided that it was conveyed, not decided, it was conveyed to all concerned that all the work orders for which works had not started at the time of enforcement of the Model Code of Conduct were to be stayed. To stop. She submits that, admittedly, the petitioner could not have started the work as on 9/10/2023. Barely 4 days after the issuance of the work order. And therefore, the petitioner cannot have any grievance with the cancellation of the work orders. Stop. She submits that the please rewrite that again. She submits that after voting for the state assembly election was over, the ballot papers were counted on 3/12/2023, and the new ministry was formed. What is the date? On
8/12/2023.
on 8/12/2023. To stop the new ministry thereafter. What did I say? Took a decision that those works which have already started before the enforcement of the Model Code of Conduct may be allowed to continue, whereas the works which had not started What is the decision? Page 7 of your counter affidavit. Serial number 2 is clear. What is serial number 1?
This is it should be serial number 1. The works for which works order have been issued, but works have not started due to enforcement of MCC.
Okay, maybe cancelled. What did I say? Last line. Maybe cancelled. Stop. Since the petitioner had not started the work, there is nothing wrong with the impugned cancellation order. Next paragraph. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. From a perusal of the work order issued to the petitioner, which are all dated 5/10/2023, there is no indication that there was some sort of selection before awarding the work to the petitioner. Stop. It therefore appears that the petitioner was randomly picked to undertake the said work, to undertake the work concerned, and that too TOO near the fag end, FAG, near the fag end of the previous ministry. Stop. Facts not disputed is that the Model Code of Conduct came to be enforced. With effect from 9/10/2023. And by then, the petitioner had not started the work. Stop. The respondents have also not disputed the manner in which the petitioner has been awarded the work order. But however, the fact remains that the petitioner apparently was awarded the work order without there being any process of selection. Full stop. At the same time, there is no dispute to the fact that the petitioner had not started the work as on 9/10/2023. Stop. Ordinarily, the respondents would be required to issue notice to the petitioner prior to cancelling the work order. But having regard to the manner in which the work orders have been issued, this court finds that the same may not vitiate the cancellation of the work orders under the given facts and circumstances. To stop, in other words, it cannot be said that the petitioner has any vested right to proceed and complete the work which has been issued to him without any process of selection. Stop. Therefore, this court finds no merit in the writ petition, and accordingly the same stands dismissed. Next para. Before parting with the records, it is seen that this court, while issuing notice of motion on (8 3/2024), had passed an interim order to the effect that no fresh work orders against the work orders that were allotted to the petitioner should be issued to anyone. Full stop. The said interim order continues till today. Full stop. It is therefore provided herein that in the event the respondent authorities decide to issue fresh work orders they should follow due process of law and also give the petitioner appropriate consideration for being allotted the works having regard to the fact that he had been earlier allotted the said work. Full stop. Next para, with the above observation and direction, the writ petition stands disposed of.
Obliged, my lord. For hearing, item number 11.
Lordship, this is a MAC appeal. However, Lordship, this is since it is a MAC appeal, it may take time. I don't know whether
A lengthy one, my lord. We shall have to, we have to appreciate
all
a
the
lengthy one.
yes.
We shall have to appreciate and read them out, all the evidences, depositions and
Yes.
written statement, and all those things are required to be done.
Okay.
We can take up some other day also if
Lordship,
Lordship allows us.
Okay. This is appeal by
By the claimants, Your Lordship. It was
Claimants?
dismissed.
Claimants, my
Yes.
lord.
Before the tribunal court, it was dismissed.
The application for compensation was filed under section 166 of the MV Act. As per the Supreme Court ruling, the claimants are required to prove the claimants are required to prove the negligence of the driver or the owner of the vehicle. Since the claimants, according to the claims tribunal, could not prove negligence of the driver in the said accident, the matter was dismissed.
it's a claim under 166
My lord.
Lordship, yes.
and evidences were led. Evidence was led,
Yes,
Yes,
my
Your
lord.
Lordship, yes, yes.
but the tribunal dismissed the claim.
Very true, Your
Right,
Lordship.
my lord.
We have
And
produced
the-
two police
the-
personnel
Okay,
in order
so-
to prove the negligence, yes.
So the claimants are the appellants now.
Very true, Your
My
Lordship.
And who's the respondent?
The owner, my lord.
Owner.
The owner and the driver.
You're for the owner and driver.
Yes, my lord.
You had contested before the tribunal also?
Yes, my lord. We
I
contested.
see.
We have filed written statement also as well.
So if any liability is to be fastened, who will pay? Owner
The
or
owner of
driver?
the vehicle,
Yes,
my lord.
Lordship.
No insurance company.
No insurance company.
The vehicle was not insured.
Not insured.
Oh.
There in the, my lord, in the autonomous district, there is no insurance office. So it is difficult for them to get them, renewed, their insurance policy.
okay.
So for them, it is difficult to travel all along for that purpose. So they simply forget about the insurance
Okay.
of their vehicle.
Okay, then we'll do one thing. We'll have it the coming week, Monday,
my lord.
Tuesday, any day which is convenient
My lord.
to the parties.
Depends upon my senior counsel.
Tuesday
Anytime, Your
or
Lordship.
Tuesday.
Next week, Monday, Tuesday. Oh. Okay.
Tuesday we'll do.
Tuesday.
My lord.
Okay, on the prayer made by the learned counsel for the parties, list the matter again on 22nd of October 2024 for hearing.
Obliged.
One thing, the LCR will be required. Paper book is ready.
Paper book is
Paper book
ready.
is
my
ready,
lord.
yes.
Okay, LCR is here.